Drugs and guns are a dangerous combination, said the U.S. Supreme Court in Smith versus U.S. back in 1993. But will it continue to be an illegal one? Because the DEA just announced that they're taking the first steps of rescheduling marijuana from being a Schedule I controlled substance in the same category as, crack cocaine, methamphetamine, so forth, down to a Schedule III with ketamine and certain anabolic steroids. What does that mean? What do you need to know? And what is the baked-in trap that you must know about that no one's talking about? Guys, let's get into it. All right, we have so much to cover. I'm going to try to do this as quickly as humanly possible. I'm going to start with a roadmap. We're first going to talk about the DEA rescheduling marijuana, cannabis. What does that mean? What's the current statutory law as it relates to firearm possession, drug use, you name it? What is happening in the courts, including right now, the U.S. Supreme Court, as well as other courts around the country, 5th and 3rd Circuit? What's the timelines for all this to come into fruition? And lastly, after we have all of our pieces on the chessboard and you understand how they move, what does this all mean? Plus, what is the hidden trap that no one else is talking about? There's the sneak peek. Let's push through this. All right, so there are 5 schedules of controlled substance. Schedule 1 is the highest and most restrictive: methamphetamine, crack cocaine, things like that, and presently marijuana, all the way down to Schedule 5, which are barely controlled substances. Generally speaking, you cannot get controlled substances over the counter. It's something you need a prescription for if you can obtain it at all. So the DEA is looking to reclassify marijuana or cannabis from Schedule 1 to Schedule 3. What's the definition of Schedule 3? We're talking about drugs and substances or chemicals that are defined as drugs with a moderate to low potential for physical and psychological dependence. If you're curious about the definition for 2 or 4, the one ahead or behind it, I'll include that in the description box as well. So what's the status of current law where it comes to possession of firearms plus some sort of use or possession of drugs? So briefly, what's the current status of law if you're someone who partakes in controlled substances, but you also want to possess firearms? Well, if you've purchased a firearm from an FFL in the last generation or so, then you're probably familiar with something that approximates current 4473 form Question 21F. Are you an unlawful user of or addicted to marijuana or any depressant, stimulant, narcotic drug, or any other controlled substance? Warning: the use or possession of marijuana remains unlawful under federal law regardless of whether it has been legalized or decriminalized for medicinal or recreational purposes in the state where you reside, end quote. So we're dealing with federal law often conflicting with state law here. But where does that question come from in the federal statutes? Well, it comes from a couple different places, but we're specifically worried about 18 U.S.C. 922 sub G, which reads in part, "It shall be unlawful for any person who, number 3, is an unlawful user of or addicted to any controlled substance as defined by Section 102 of the Controlled Substance Act," which you can look up at 21 U.S.C. 802, copied below in the description box, but I'm also going to cover what's the definition of a controlled substance. This is important. Stay with me. Controlled substance, specifically at sub 6, quote, "The term controlled substance means a drug or other substance or immediate precursor included in a Schedule 1, 2, 3, 4, or 5 or of Part B of this subchapter." So it's important to understand that when we're talking about possession of firearms, if you're an unlawful user of something that falls under the Controlled Substance Act, plus you're in possession of a firearm, that might equal a crime under federal law. That's the hang-up here. Now, likewise, 18 U.S.C. 922 sub D, just a different part in the same federal statute that criminalizes the individual possession if you're an unlawful user of or addicted to a controlled substance, likewise criminalizes the sale of firearms or ammunition to someone who fits this criteria, also copy-pasted in the description box below. That's super short, the current status of federal law. What has the courts had to say? Well, since the Brune decision from June of 2022, remember that nearly every regulation and law, there's some exceptions, let me know in the comment field if you want me to get into those, that deals with Second Amendment rights must now pass the Brune history and tradition test. Back on January 5th of 2024, In the case of U.S. versus Daniels, this case was distributed for conference to the United States Supreme Court. Now, the Daniels case came out of the gun-friendly Fifth Circuit Court of Appeals, which is based out of Louisiana and covers both that state as well as Texas and Mississippi. In that case, the Fifth Circuit basically struck down that 922 sub G sub 3 that criminalizes possession of a firearm by someone who's an unlawful user of an illegal drug as applied. The circuit court found that the policy was unconstitutional as applied to a man who faced a conviction after admitting to having used cannabis while in possession of a gun. We did a whole video on that. It's going to be linked at the end. Guys, stick around to the end so that you can see the big legal trap here that no one is talking about. And don't forget to hit that like button if you want us to continue to cover topics like this. And now back to the video. Now, the Daniels case has drawn attention because it is one of a few cases holding an existing federal firearm law to be unconstitutional, at least as applied, because it could result in Supreme Court involvement. Not so says Tom Grieve, so says the Congressional Research Service in a report that is also linked in the description box below. Notably, that same report does include that, quote, Section 922 sub G sub 3 has also gained broader public attention because of the recent indictment, end quote, against President Joe Biden's son, Hunter Biden, who has been charged with owning a gun while also admitting to unlawful use of crack cocaine years ago. Now, while this has all been playing out in the Fifth Circuit and, of course, in the political arena of the Hunter Biden case, in a separate case in November of 2023, the Justice Department counseled the Third Circuit Court of Appeals. That's the one that's based out of Pennsylvania and covers New Jersey and Delaware, as well as, don't forget, the U.S. Virgin Islands, that the historical precedent that supports such criminalization of firearm possession for drug users is sitting, in their view, comfortably, quote, end quote, on that. The government broadly noted as part of that case that cannabis consumers with guns pose a unique danger to society, in part because they're, quote, unlikely to store their firearm properly. That's what the Biden administration said, not what Tom Grieve said. That's what the Biden administration said. So that's the current status of where we're at in court. The U.S. Supreme Court has not done anything with that. I think in part, if memory serves, the government said, look, there's a few other cases with ramifications that could tie into this. Here's this for conference, but sit tight for right now, and the Supreme Court has. Now, just because the DEA has announced that this is what they're looking to do, does that mean that it happens today? Long story short, it could be weeks, but more likely months and perhaps even longer. Now, nothing has changed as of the moment of recording this video in May of 2024. The DEA will likely publish its ruling, then that will trigger a public comment period for the official record that will last about 30 to 90 days before moving to an open-ended formal hearing. Following that, the DEA will review along with a few other government agencies, and I'm sure some politicians paying very close attention. If they still want to move forward with the final rule, which they probably will if they announced it, then there is still no strict timeline since this is not statutorily defined, but since the DEA is required to review and respond to every comment submitted during the notice period, it likely won't happen overnight. If and when the final rule is made, it will not become effective, keep in mind, until 30 days after it is published on the Federal Register. During this time, that's the 30-day period, someone with standing has 30 days to file a lawsuit to seek judicial review of the agency's decision. That's code for sue the government. If that happens, it is then possible that the effective date of the reclassification from Schedule 1 to Schedule 3 could be delayed or indefinitely postponed and perhaps even struck down. Who the heck knows? But that's the quick timeline and what that roadmap looks like. So now that you have the chess pieces on the board, let's start moving them around. What does this all mean? Now, remember that the federal law says that you cannot be an unlawful user of controlled substance, and that the reclassification of cannabis from a Schedule 1 to a 3 does not change the fact that it is, in fact, still a controlled substance. What this could open up is that there now could be legal use, as with other non-Schedule 1 controlled substances. It is not illegal to use Ambien or oxycodone or whatever else, maybe ketamine, provided that you're doing so lawfully. Simply put, the fact that it is no longer going to be a Schedule 1 means that under federal law, independent of extreme research cases with special permissions, there may now be a federal legal road. Emphasis on may, lots of details. Will this mean that you can possess a firearm in states that allow recreational use, of which there's presently, I think, about 24? Well, assuming that you follow all applicable laws and therefore you do not trigger the unlawful user wording, maybe. Check your local listings, check with attorneys in your state. This is not legal advice to folks in 50 U.S. states, or at least the 24 that allows recreational use and the many more that allows medical use. Why can't it be specific? Frankly, there's just simply way too much regulation and red tape to clearly see through the mud of regulation and lawsuits. But one thing is clear. This at least opens up the possibility that it can happen, subject to those details. What's my bottom line? I think there will be a legal road, provided that you are following state law, that you will then be in compliance with federal law, and you're going to be good to go. That's what I think is going to happen, but that is not legal advice. That is legal prediction. I mentioned and I teased that there is a legal trap. I've not gotten to it, but here it is. 18 U.S.C. 922 sub G. It shall be unlawful for any person who is an unlawful user of or addicted to any controlled substance. Addicted to. We've only been talking about unlawful user of. That's what everybody's been hung up on, because you cannot be a lawful user under federal law. Will the regulators, will the prosecutors, will the police, will the courts simply pivot from the unlawful user of clause to the addicted to clause? But Tom, I'm not addicted to marijuana. I'm not addicted to cannabis. I smoke once a year, once a quarter, once a month, once a week, once a whatever. But I'm fine. I pay my taxes. I'm W-2. I've got kids, maybe. Who knows? Well, the Controlled Substance Act defines an addict as this. The term addict means that any individual who habitually uses any narcotic so as to endanger the public morals, health, safety, or welfare, or who is so far addicted to the use of narcotic drugs as to have lost the power of self-control with reference to this addiction. That's a lot of open-ended language, folks. Endanger public morals, health, safety, welfare, or lost power of self-control with reference to this addiction. So public intoxication, is that endangering public morals? It might not be in San Francisco, but it might be in Oklahoma City. And on top of the fact that you have different areas that feel differently about drug use, now we have the same question about how do they feel about guns. And quite often, people who take a left on guns may take a left on drugs, and likewise, right on drugs, right on guns. So how are they going to feel about once we start basically connecting the two? How about the phrase that talks about what is a loss of self-control? Is monthly use per se a loss of self-control? How about weekly use? Does the frequency of use even have any kind of bearing whatsoever on whether or not you're addicted? You can see all of these questions arising. Ultimately, if the law is struck down by the U.S. Supreme Court in the Daniels case or another case, at least the guardrails might be put up somehow on how we might be getting some clarity to avoid an era of, frankly, quite unequal prosecution across America under this statute. I do predict that the U.S. Supreme Court will, at a minimum, with time, allow laws that prohibit individuals from being under the influence from possessing firearms as being constitutional and legal, since there is at least some history there of states doing just that. Whether the courts disallow individuals who are drug users, perhaps legal ones, but are sober from possessing firearms, that's definitely a major step, and I would say even a leap into something that we have covered in other videos in depth, and we've examined that history. If you want to see more about that, check out our outro video. In the end, only time will tell. Hey, congratulations. You made it to the end of another one of our videos. Give yourself a pat on the back. And here's a little treat for you, our ever popular quote of the day. This one comes from Carl Jung, quote, "Everything that irritates us about others can lead us to an understanding of ourselves." Let me know in the comment field what you think is going to happen. Don't forget to hit that like button, and I'll see you in the next one. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.